Great, has agreed to do this presentation. We are delighted she is. She is the volunteer attorney for the Minneapolis Area Synod, works in this area of employment law. Presentation about 30 minutes and then time for question and answer. There is food and light snacks and beverages over here. Feel free to move around. We may have a few folks still joining us, but I think with that, I'll turn it over to you.
Hello everyone, thanks for taking time out of your afternoon to come in and learn about a very important but not a very exciting topic. As Doug said, my name is Julie Grape. I'm a partner with a law firm called Connor & Winters. It's actually a Tulsa law firm, but I office on St. Paul here in the Twin Cities. So today we're going to start talking about a little bit about the overtime regulations. Before I start, I need to tell you something you probably always hear when lawyers start doing presentations, is that I'm going to give you the high level, the 30,000 foot level rules, and we'll do some discussion, and please ask questions if you have them. What is going to be hard for me to do is talk about very specific scenarios. As you go through this, you'll see everything says facts and circumstance based. So if somebody raises their hand and said, you know, I have an employee named Julie that works so many hours a week, you know, it gets really, really difficult to answer those types of questions in this situation. So I just wanted to let you know that after hearing all this, you'll probably have a lot of questions. If you have a good employment law attorney in your church, at your organization, that you can bounce ideas off, that's really the best way to do it. I used to work in human resources for about a decade and then went to law school and actually became an employee benefits attorney. So I do mainly employee benefits, which is retirement plans, health plans, Affordable Care Act, that kind of thing. But my practice is always crossing over into the employment area. So when I was asked if I could give an update on the Fair Labor Standards Act, I said, and the overtime rules, I said, sure, that would be really, really fun. So thanks again for being here, and we'll just jump right in. The Fair Labor Standards Act came about in 1938. It covers 4 things that you'll see on the slides: minimum wage, overtime, record keeping, and some type of youth employment standards. Today, we're really only going to focus on the overtime pay requirements. So the overtime pay provisions of the Fair Labor Standards Act cover employees in the private sector as well as governmental employees. And in a nutshell, the second bullet tells you what the overtime provisions are. Covered, non-exempt employees, and we're going to talk about all 3 of those words, covered, non-exempt, and employee, have to receive overtime for hours worked over 40 in a work week at a rate of not less than 1.5 times the regular pay. It says employees, so notice the 3 hashes, and we can get this information out to you, the slides, if you want them afterwards too. Independent contractors are not employees, so independent contractors not covered under the Fair Labor Standards Act. Volunteers, unpaid volunteers, not employees. And unpaid interns, not employees. So you don't have to worry about those groups of people. Next, let's talk about what covered means. It says you have to be covered and a covered employee. So who's covered by the Fair Labor Standards Act? There's 2 ways you can be covered. There's something called business coverage or enterprise coverage, and then there's individual coverage. So we're going to talk about the business coverage first, which is a little more complex and difficult. Enterprise or the individual coverage is really easy. So unfortunately, a lot of my clients, and most of my clients are religious organizations and nonprofits. A lot of my clients, for some reason, hopefully thought past tense, not think, that churches are automatically exempt from the Fair Labor Standards Act. Not true. Churches are only exempt from being covered under the Act if they fall under the enterprise coverage rule that you'll see here. And there's also a couple other exemptions we'll talk about in a few minutes. So what's enterprise coverage? The Fair Labor Standards Act says that your business will be covered, and you'll have to comply with minimum wage and overtime rules, if you have at least 2 employees and your organization does an annual volume of business of at least $500,000 a year. The second bullet is really important. no matter what your size, no matter how many employees, the second bullet, the organizations under the second bullet automatically swept into the Fair Labor Standards Act. Hospitals, medical care, schools, preschools, and government agencies. That means if your church, for some reason, would be not covered under the FLSA, but you have a preschool, the employees of the preschool are always covered under the Fair Labor Standards Act and will have to comply with the minimum wage and overtime requirements. And the last bullet, the business or enterprise coverage isn't applicable to a religious activities that aren't in substantial competition with a for-profit enterprise. So the first and the third one kind of combines together. As you'll see, I put a note on there for the $500,000. Donations don't count. Things that are in direct competition with for-profit enterprises count towards the $500,000. So if your church if you have a church down by the new US Bank Stadium and you rent out your parking lot on weekends for the Vikings games and you get income from that, that is in direct competition with a for-profit business, so it's counted toward the $500,000 amount. If you have a church or a synagogue and you don't have parking lots, you don't have preschools, you don't have thrift stores, then it could be that your business is not covered by the Fair Labor Standards Act because nothing you do is in direct competition and rises to the level of generating money in a business. So that's the business or enterprise coverage. So my church could be exempt from that, from the business or enterprise coverage test of the Fair Labor Standards Act. So people go, ooh, great, we don't have to comply, our employees aren't covered. Not necessarily so. There's something called individual coverage that can bring individuals in under the Fair Labor Standards Act, and that's employees engaged in interstate commerce. Back in 1938, when this came about, I can guarantee you that interstate commerce was a lot less prevalent than it is today. Interstate commerce, as you can see, are simple things like calling people in a different state, sending email or US mail to somebody in a different state, processing donations from somebody in another state. And aren't you all glad that we have Wisconsin only 30 miles away? Because that makes almost everything we do could be considered to be interstate commerce. In the last bullet I put on here, ordering supplies that come from another state. When I was doing research for this presentation, I found it wasn't an official opinion, but it was folks online going back and forth. And one of the organizations was saying, well, okay, my church is not a covered business. We don't have $500,000 in revenue. So I have a janitor. She's not under it for individual coverage. And then they started talking about it. And they said, okay, she doesn't need email for her work. She comes in and cleans. She doesn't get mail or send mail on a regular basis. She doesn't do anything with out-of-state credit card transactions, but she orders supplies. She orders supplies off of Amazon.com. They come from a different state. So even if an individual looks like they would have no interstate nexus at all, if you regularly order supplies that come from a different state, it's called, oops, oh, that's really touchy. It is called interstate commerce. So just know, I guess my advice to you is probably this isn't going to be a good exception for most everything we know. So what are the final regulations that people are talking about? They were issued in May of this year. The Department of Labor put out final rules, and are effective December 1st of 2016. So thank you all for being here right now. You've got a couple of months to prepare yet, and I think that's going to be really helpful for individuals to have time to think through your strategy and know what you're going to do. So what the final rules say is that effective December 1st, the weekly earnings exception amount is going from $23,660 up to $47,476. That's the main thing we need to pay attention to. There's also an increase in a highly compensated employee definition, which doesn't affect most people. And the third bullet, threshold amounts are going to automatically escalate or be updated every 3 years. Since the Fair Labor Standards Act was put into place in 1938, I think this limit has been raised 7 or 8 times. I think the last time was in the early 2000s. This is by far the biggest jump, from $23,000 to $47,000. And as you can see, from now on, we have to pay attention. Every 3 years, that $47,476 might go up. So if you are really close to paying people around that number, from now on, you're going to have to watch it every 3 years. So why do we care about the Fair Labor Standards Act? I've had some small organizations just say, other things, bigger things to worry about, I'm not going to worry about it. But it can be quite costly for employers. If somebody would come in and claim a violation of the Fair Labor Standards Act, it's typically, sometimes it's employees, more often than not what I see are former employees, maybe former employees who didn't want to get terminated, who got terminated, and then all of a sudden trot right down to the local Department of Labor office and said, you know what, I was being paid as an exempt employee, and I think I should have been hourly, and I wasn't getting overtime. So then the Department of Labor comes in and looks at that, and you could end up paying that person an amount of unpaid overtime for the past 2 to 3 years. There's going to be interest and penalties. Criminal sanctions for some people, not for anybody in this room, because criminal sanctions are usually if you willingly, knowingly violated the law. And we find that that's really not the case for most of the nonprofits I work with. And then the icing on the cake, you get to pay attorney's fees for that attorney that busted you. So, and it's not just the one employee that complained. What can happen is the Department of Labor person comes in, knocks on the door and says, oh, you have 72 employees. I'd like to see all the records and make sure there aren't more people that should have been paying overtime and getting overtime. So please take this seriously, think ahead, and do not break the rule. So when I talked earlier, I said there were 3 words that we're going to talk about. We were going to talk about who's covered, and we did that, the business or individual coverage. Who's an employee? We saw who wasn't an employee, independent contractors, interns, volunteers. Now we're going to talk about, it said non-exempt. So now we're going to talk about some exemptions. If you would look at the Fair Labor Standards Act, and I wouldn't recommend that, it's pretty dull. There's a large list of exceptions. There's certain exceptions for agricultural workers, for kids babysitting, there's just a whole laundry list of very odd exceptions. There's one called the white collar exemption, and I think this is probably the most common one that we all usually hang our hats on. It says that employees employed in bona fide categories, which are executive, administrative, professional and outside sales, some certain computer people too, can be exempt from the overtime rules if they meet 2 different tests. One is a duties test, so they have to be a little bit more autonomous, a little bit high-level workers, and the duties test is spelled out in the regulations, and they have to make a certain rate of pay. And that certain rate of pay is the $47,476 we talked about on the early slide. So if you have folks in your workforce that meet the duties test and fall within one of these professional categories and make at least $47,476. If that's everybody in your workforce, you do not have to pay attention anymore to this presentation. If that doesn't work for you, there's also something called a ministerial exception. And the ministerial exception is a little bit more of a gray area, because if you go to the Fair Labor Standards Act, it does not mention the word clergy, minister, deacon, anything like that. Where this came about is under case law in the federal and state courts. In 2004, the Department of Labor has this thing called Field Operations Handbook that had this lovely clause in it that's not in there anymore. In 2004, if you looked at the handbook, it said that certain members of religious orders who serve pursuant to religious obligations in religious organizations are not considered employees under the Fair Labor Standards Act. That just went away. And when we try to find out why it went away, there's nothing there. It's just not there anymore. So we used to be able, before 2004, to hang our hat on that, but that's not around anymore. But federal and state courts have some very good case law. And they do recognize a ministerial exception. So although it's not in the statute, it's available for use if it fits. It's for those people who perform primarily religious duties. The person should be ordained, credentialed, commissioned, or called as a minister. Their job description should say that they're part of the ministerial team, part of the ministerial staff, and emphasize and list the religious duties. Now, not every single part of the job has to be a religious duty, but the majority of it has to be a religious duty. So if you have individuals in this case, this group of people can also be exempt from the Fair Labor Standards Act. So even if they would make under $47,476, there's and they fit all the requirements, you would not have to pay them overtime for hours worked over 40. So employees who fall under the exception, unfortunately, or I shouldn't say unfortunately, it's confusing, because it would be those who, if you went to court, you'd wanted to hold up in a court of law, that the court would say, yeah, these folks are ministers, we can see that. It's not without risk. Again, consult your friendly employment attorney, because as I said at the beginning, this is very facts and circumstances based. So you need to look at what that individual does, what their duties are, how the organization and church perceives them. Are they commissioned or ordained? Are they working on are they going to seminary? All of those things play into this. Some examples in the courts that have been for the ministerial exception: called teachers in a Christian school, they were exempted from overtime. U.S. missionaries starting up new churches. I put U.S. missionaries because this particular opinion dealt with folks in the United States starting up churches in inner cities and things like that. And that's all they did for a living, so they said, the court said, yes, those do meet the ministerial exception. And finally, ministry staff that regularly conducts Bible study, leads prayer, and does evangelical outreach. Those are some of the things the court said would qualify for the ministerial exception. The final bullet I put on the slide, and this isn't such an issue in Minnesota, but if people are not from Minnesota or will watch this online later, I wanted to bring it to their attention. There's also Minnesota has a state Fair Labor Standards Act. Because it's not good enough just to have the federal one, we have to have a state one too, and of course, they're not the same. So we're lucky though that Minnesota's is a little looser, so you always have to follow the more stringent guidelines. So for us in Minnesota, we follow the federal Fair Labor Standards Act. In other states, they might have a state law that's more strict. You need to know about that and follow it. For example, in Minnesota, you don't have to pay overtime if you, for some reason, would only fall under the Minnesota rule. So you'd be exempt from the federal rule, and somehow you'd fall under the Minnesota rule. Again, your friendly employment labor attorney can help you with that. You don't pay overtime unless the person works over 48 hours in a work week. The other nice thing about the Minnesota rule is they actually have part of the statute that exempts ministers. It exempts ministers, deacons, and others who serve pursuant to their religious obligations at a nonprofit institution operated by a church. So just to let you know that the Minnesota law spells it out a little more clearly for us. And again, in general, we're going to be complying with the federal law, but I just wanted to let you know that there are a few differences. So let's look at an example. Director of Music Ministry. Start at one of the first things we talked about. Is the person an employee or an independent contractor? If he or she is an independent contractor, end of story, not subject to the Fair Labor Standards Act because they're not an employee. If they're an employee, you want to see if you can, it's always easier to take people out of the Fair Labor Standards Act because number one, you don't have to track the time, and number two, you don't have to worry about overtime pay. So does the position meet the white collar exemption? Look at the job duties test. With a title like Director of Music Ministry, it probably meets the job duties test. But what about the salary? Does this individual get paid at least $47,476 a year? If they do, then they could be exempt from the Fair Labor Standards Act under the white collar exemption. But for some reason, if they don't worry, well, look at the ministerial exception. Would this person be considered a minister in the eyes of the court, in the eyes of the church or the organization that employs them? What does their job duties say? Are they part of the ministry's team or ministry staff? Do they have a theological background in education? Look at all those things. It could be that they might be exempt from the Fair Labor Standards Act under the ministerial exception. And again, not so much in Minnesota, but remember that state law might be a little bit different. And the last bullet, really the most common sense bullet, does the person work overtime? Because if the person doesn't work more than 40 hours a week, it's really not as big a deal. If the person is non-exempt now because it went from 23,000 to 47,000 and the person makes somewhere in between, doesn't work overtime, you don't have to worry about budgeting for overtime, paying overtime, wondering how you're going to get that money. But I still really would recommend, and I'll say this probably one or two more times, that you have any now non-exempt person keep a time card. Have them keep time records. It's kind of hard if somebody's been exempt for 15 years and all of a sudden you make them start filling out a timesheet. But that will do nothing but help you if the Department of Labor would pay a visit to your organization and say, whoa, we think you might owe some non-exempt people overtime. You can pull out the time records and say, no, look, we've kept valid time records and everybody is being treated fairly. So that's what you kind of need to do for employees in your organization. I'll talk about the options and then I'll talk about what a couple of my clients have been doing. So options for employers with non-exempt employees. So you line up, what some of my clients have been doing is just line up people in salary order and look at that $47,000 range. See who falls close to that range. If one of the employees falls close to that range and really does exempt type duties, then maybe you want to consider bumping that person up to $47,476 so you don't have to worry about paying overtime. If the person is lower on the pay scale and you're not rich and can't bump everybody up to $47,000, you could consider limiting overtime or forbidding overtime for somebody that makes under that salary cap. If an employee, the rules say that if an employee does work overtime, you need to pay it. You can discipline them then afterwards for breaking a law, or not breaking a law, breaking your personal policy or your company policy that says you don't work overtime without permission. But I just want to make sure if somebody works overtime, you need to pay them the overtime and then deal with the performance issue if they weren't supposed to. But notice there's a 2A and a 2B, because if you limit people from working overtime and they've worked overtime in the past, you probably have extra work that's not going to get done. So you have to look at perhaps hiring additional part-time or full-time people to pick up the work that the people who used to be exempt and would do can no longer do because of the time constraints. Number 3, in a fantasy world, we could just increase our payroll budget to cover all the non-exempt employees' overtime costs, or bump everybody up to $47,000 because we're all in favor of paying people a great wage if we have the budget that can afford it. So if you can't bump everybody up to $47,476, at least look at the people who are going to have to work overtime and make sure that you figure out from a budget perspective how that's going to work. So now I'm going to talk about a few things that have come up for issues with clients that I've worked with, and then we can open it up for questions. Use of electronic devices. Everybody's got their phone out. Nobody's looking at it, so thank you very much for that. What happens if now a non-exempt person regularly, and this is what's really, really hard, and it's really been hurting morale at some of the organizations I've been working with. You have people who used to be exempt, or are exempt until December 1st of 2016. They're good people, they're passionate people, they love what they do. They're caseworkers that stop on their way home from the grocery store and just check in on their client because they're in the neighborhood. Well, if those people are now non-exempt, the law says you have to pay them for every minute worked. So some of my clients are actually taking away their mobile devices because they said, we know these people are going to want to work, we know they're going to be checking email at home, and we can't afford to pay them overtime for checking email at home. So think about what you're going to do with the electronic devices. It just seems counterproductive, but you may have to tell people if they're not exempt, I'm sorry, you can't check your email unless you're in the office. So that's one huge thing that people are really taking some time and thinking through and figuring out what to do. Another one, number 2, says, are benefits tied to exempt, non-exempt status? This doesn't happen a lot, but I've seen it come up enough that I wanted to mention it. Look at your policies, look at your handbook. Some of the older policies and handbooks say exempt employees, blah, 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 get these benefits, non-exempt employees get these. Well, now if your non-exempt employees are going to be all these people that make up to $47,000 a year, you're going to have a lot more people in that pool probably. So really look at things in your organization where they use the words exempt and non-exempt and make sure that people are getting or will get the right benefits based on that. And then number 3, does the employer have adequate timekeeping systems in place to track? I've mentioned this before. You just really, really want to make sure. A lot of organizations I've worked with pay most people over $23,000 a year. They met the job duties test. So they really had very few non-exempt employees. Timekeeping is a foreign thing for them. So now they're looking into, wow, do we get one of those old punch clocks that go boom, boom, when you're at a factory? Or do we use a computer system? Do we just have Julie write on a piece of paper and turn it in every week? What are we going to do for timekeeping systems? Who's going to monitor that? Where are we going to keep it? What's the records retention policy on it? That whole big area of timekeeping is opening up. So one last final observation, and I hope this doesn't happen to a lot of you. I don't know the makeup of your organizations, but some of our clients are having a really, really hard time with this because they have, say, 2 managers. One makes $46,000, one makes $40,000. They both have the title of manager. They both do the exact same thing. On December 2nd, Joe is going to be able to check his email from home. He's not going to have to keep a time card because the employer decided he's only $1,000 from that limit. We're going to pop him up to $47,000, and we will make him so he continues to be exempt. He can still do what he does, and not really, life won't change for him. Jim, on the other hand, who made just a few $1,000s less, but does the exact same thing, all of a sudden now is non-exempt. Jim can't check email from home. Jim can't stop and check on clients on the way home from the grocery store. Jim has to track all his time. And it is just really not a morale booster. You still have 2 people doing the exact same job and being, unfortunately, because of the rules, treated somewhat differently. So that's why I encourage you all to go back to your organizations, look at people where they fall, see if they can maybe use some of the exemptions, but be fair about the exemptions. I also had a client, I was just helping them review their job descriptions a week ago, and they had a youth minister who wasn't a minister, a youth director. And they were trying to figure out, because he went to camp a lot, spent overnights a lot, drove around a lot, and they figured during the busy summer months probably worked 60 hours a week. And they said, there's no way we can pay this person overtime. And so they were doing everything they could to try to figure out how to make the job exempt. And I said, well, that's not really how it works. You don't start with the end result in mind and work backwards. You really have to look at the rules and say, if we're fair and equitable, can this position really fit the ministerial exemption? Can it really fit the white-collar exemption? If it doesn't, it doesn't. And you just need to figure out what you're going to do about overtime, what you're going to do about timekeeping. But I really wouldn't encourage anybody to say, okay, have kind of preconceived notions in your head about, well, this job has to be exempt because they work 60 hours a week. That would be nice if it worked that way, but it really doesn't. So that's really what I had to say. You've got several months to go back and look at this. For some of you, it may not be a big problem at all. For some of you, it may be quite a problem. I work with a couple of social service agencies who have a lot of home health care workers, and they get a lot of government funding, and the government funding is 3-year funding. It's not going up. It's not going up for 2 or 3 years. It might not even go up after 3 years. And so they're working really, really hard to try to figure this out. And there is going to be some staffing cuts because that's how they're going to have to deal with that. So I will take any questions if I can. And again, I'd be happy to answer general questions. If it's super, super specific, maybe I won't be able to. Yes.
When you document whether a position is exempt or non-exempt?
How do you document it? Usually in a job description. I recommend on a job description that it has exempt or non-exempt on it. And if it's exempt and there's certain job duties in the regulations, it's always nice to make sure that the job description kind of has it. So it's very easy when you look at it. So, oh yeah, I can see where it's exempt. Julie's autonomous. She can do this on her own. She doesn't have to be supervised every minute. You know, that kind of thing. But yeah, if you put it on the job description, it works the best. Yes.
Can you address, we have part-time salaried employees. Would you recommend just switching to hourly? That's what I've been told.
Probably the easiest.
And figure out what their one works 15, for example, they're supposed to work so many hours, but they're pretty autonomous, so they don't even work in the office. But,
Yeah. I would recommend switching them to hourly. It's
Okay.
just the easiest.
But you don't have to pay them over, do you have to pay them time and a half? Like, let's say they're budgeted for 15, does the law say if they work the 16th hour, is it time and a half or just an extra hour of pay?
Just an extra
Okay.
hour of pay. I guess you could have a policy that you could pay them more, but the federal law and the state law say no, not unless they work
No, that's
40
fine.
in a work week. Yes.
Are there some rules that are really clear, like if they have a desk in the workplace, then they are in fact employed there, or if they have the right to hire and fire, they're
No, it's, over the past, I would say, decade, it has gotten more and more murky as telecommuting and working from home. So they really don't have any things like if you meet this specific requirement, you're an employee, or if you meet this specific requirement, they're automatically white-collar exempt. I don't know if any of you remember, I was looking it up just before I came in. I think it was in the early 2000s with Microsoft and their worker misclassification. Now, this doesn't have to do with overtime, but they were misclassifying people as independent contractors instead of employees. Before the case got done, Microsoft settled for $97 million because they have lots of employees that they were considering independent contractors. So most of my clients err on the side of just saying, you know what, they're probably employees. Unless you're hiring them to develop a website and 6 weeks later they come in and say, here's your website, and you say, this is awesome, and you pay them, that's probably an independent contractor. But in most cases, they're probably employees.
This is a huge issue that, not so much in the room, but a huge issue that we still work on at IWJ. It's just an enormous amount of misclassification that's happening all over the economy as folks are classified as independent contractors that clearly don't meet any of the independent contractor rules. It's just rampant all over the place. So again, I think doesn't impact so many of us in this room, but for people in your congregations and people in your neighborhoods, this misclassification, calling people independent contractors, I run into it time and again all over the Twin Cities.
Good observation. Did you have a question?
So under the ministerial exception, if there's a lay minister sent to a church to serve, would they fall under that?
They could.
They aren't credentialed yet.
They could.
Okay.
They could if, does the church treat them like a minister? Does the staff treat them like a minister? Does their job description say they're part of the ministry team? Are what they're doing mostly minister stuff?
Okay.
Everything adds up, and again, there's no bright line saying, just because you're not ordained, you can't use the ministerial exception. That definitely helps put it over the edge, but it really depends on all the facts adding up.
And the exemption would then say they don't have to make the $47,000?
Right.
Is that-
What the exemption would say, you can pay anybody anything you want. What the ministerial exemption would do is say, if the person makes less than $47,476, you don't have to worry about paying them overtime. And they work over 40 hours a week, then you don't have to pay them overtime. That's what the white collar and the ministerial exemption get you out the overtime requirements. Anything else?
Can you talk a little bit more about the white collar exemption and how that might apply to like a youth director in a church? Does that apply to them? They're leading and finding their volunteers, they're directing the work,
It could. It typically, most of my clients have used that white collar exemption. Again, I forget, I didn't look up, I apologize, I didn't look up all of the rules and duties, but you have to be autonomous, do a lot of your own work, kind of be more in a leadership role or something where you're not putting widgets into a box, you really have autonomy and doing, making the job, kind of doing some of the duties on your own time, your own volition. But most of the organizations I work with would say that like a youth person would be under the white collar exemption because their duties probably would get you there. But now it's that making that $47,000. So when the limit was $23,660, we didn't realize how good we had it. $23,660, we're like, okay, if people are full-time, we don't really, nobody even thought about that. But it was supposed to be over $50,000 when the regs came out, the temporary regs came out, proposed a year or so ago, and it was actually over $50,000, and people just went ballistic, and the Department of Labor lowered it down to $47,000. So, not really a gift, but something to make it feel better. But
is there ever a time where it's okay to use like comp time for if somebody, especially a youth director, if they're out on a trip?
not for non-exempt. For exempt people, you can use comp time and stuff. If they're non-exempt, they need to get paid for every hour worked on the floor.
So if they're overnight, it's 24 hours?
Well, it depends. There's a fact sheet on the Department of Labor website. It talks about overnight, and I think what it says, I looked at it a couple of weeks ago, and if you just go out on the Department of Labor website and Google fact sheet and overnight days, I think, what it really said in a nutshell is if the person, even if they're overnight counselors at a camp, if they really have a time of like 8 hours that they could sleep, and they're not on call or on duty or doing bed check every hour, then they don't have to get paid for that 8 hours. But if they're overnight and they're walking security once an hour and they're really on the clock, then they would need to get paid for those 8 hours. So again, facts and circumstances.
If a pay period, a pay period is like a 2-week period. So the 40 hours, if you work 50 hours one week and 30 hours the next, it pays overtime in 50.
It's 40 hours in a work week. You can set whatever the work week is, but it's a consecutive 7-day, 24-hour-a-day period. So it can start on a Monday or Tuesday or Saturday at noon or wherever you want. But unfortunately, it doesn't look at the pay period. It looks at the 7-day week. Really good question.
And the employer can set the work week?
Yep, you
to
just
his
set
or
the
her-
work week.
yeah.
And different people can have different work weeks. Try to do that for timekeeping. But you
Right.
could.
Where do you document that?
Pardon me?
Where do you document that?
The work week, usually in your payroll policies. You just say, if you have a handbook or a payroll policy, it usually says that, for purposes of such and such church, the work week starts on Monday morning. Or something like that.
So if you have a non-exempt person, then, did I hear you correctly? If they're scheduled for 40 hours for that week, but now let's say it's Monday and something happens and they need to stay late Monday night, you can't say to them, well, we'll knock off early Friday.
Well, yeah.
You can, and you don't have to pay them overtime then, right?
You can. What you can't do is say, these are really good questions, I'm thinking about it, make sure I don't screw up my answer. What you can do is, if it's in the same work week, you can do that. But what you
Okay.
can't do with comp time is you can say, Julie, if
Okay.
you work all day this Monday, I'll give you the following Monday off.
Okay, perfect.
So yes, you can, as long as, so the rule, it's pretty easy, it just says for hours worked in a work week over 40.
Thank you.
So there is, say somebody gets paid right now $40,000, and we decide not to go up there. Mathematically, 40 hours would be $19 an hour, $19.23. I can put that pay actually wherever I wish, right?
Okay.
So like if they're averaging 45 hours a week,
I have a client that does that, but I didn't want to tell you that because I think it's depressing. What you can do, I should tell you that, it's an option. It's depressing in the way it's almost impossible to communicate and make that person feel good about it. So you have somebody that works 5 hours of overtime every week. You know what? It's just the way it is, 5 hours a week. So you pay that person a certain amount, say $40,000 a year. You can backwards do the math and then say normally instead of getting paid $20 an hour, I'm going to pay you $18 an hour, but don't worry because you'll make it up in the time and a half and overtime. So at the end of the year, they're making the exact same amount of money, but you know what Julie heard? Julie heard she just got a pay cut. So we have some clients that are doing that and they're really sitting down and HR people are trying to talk to people and doing the math and getting the calculators out. And at the end of the day, they walk out going, I got a pay cut. So it's, if you can figure out a way to communicate it definitely can be done. It's an option.
but there's no law that says 40 hours, you divide out what they're making now to, it's whatever you want to pay them
Yeah.
per hour. Not that
Right,
it wouldn't
as
be fair.
as long as you're not violating the minimum wage, which is what, now $9.50
Yes.
an hour, I think, for large employers?
And I do struggle too with the overnights. So we have a couple mission trips, they're gone for 7 days. And,
Yep.
okay, so they're sleeping, but if somebody has a problem, that's one staff member and many volunteers. Can that staff member, the way I see it is, if that staff member can leave that area, they're off the clock. But if they have to be there for whatever reason, they're gonna be on the clock, so that's 24 hours
Yeah,
a day.
that's facts and circumstances. Yeah, check out that fact sheet on the Department of Labor website. I can't remember exactly all the nuances, but it does actually a pretty good job of spelling it out, because that's one of
That's
the
just a
issues,
struggle
too.
because, a business trip,
Oh,
okay,
yeah.
so if they're at the hotel for 8 hours, they don't have to pick up the phone, but
Right, exactly. I
working
know.
a mission
I
trip,
know.
they have to get
I
up
know.
and.
You guys are all gonna go out and stick your head in a pail of cold water after this meeting. So, one thing I wanted to bring up, and any more questions would be great, but we do www.benefitslawupdate.com is a blog that a colleague and I do, and it's written for HR and business administrators of mainly nonprofits, mainly religious, but most nonprofits fall under the same laws. So we try to blog once or twice a month, and we do it on things that come up. You might have seen, if you registered for this, you might have seen a link to the article, the blog site and the article. We do things when regulations come up. We remind you when certain things are due. If there's interesting court cases, we're just like, what? And it has to deal with employment or HR or benefits. We'll write little things on that. And I told, don't tell my mom this if you ever meet her, but I told people that I write it in a way that my mom can understand it. So, because my mom doesn't know anything about benefits. So it's really, if you're looking for one of those lawyerly things with footnotes and really long, this is not the place to go. Although my colleague likes to write that way, so I'm still telling him that that's not what's going to happen on this website. So there are 2 or 3 or 4 paragraphs explaining what's going on. So if you go onto the website, you'll see a subscribe. So please feel free to subscribe to all your friends. And it's really kind of our public service, a way of getting information out to people that you may otherwise not know of. So any final questions? Remember, your employment attorney is your friend. So after seeing all this, you may want to go have a conversation with somebody. So thank you very, very much for your time. I do have a couple of cards up front if you're interested in taking them. I'm happy to answer just real general questions free of charge if there's anything I can do to help. So thank you.